estate planning, real property, surrogates court, they collide. Have a situation where there is an adult person came to me, child of deceased parents, mom and dad. One of the parents passed away. The second parent remarried, had been with that person for more than 30 years. Upon the passing of that second parent, what happens to the house? Well, the adult child that I spoke to, one of 3 siblings, this adult child indicated that my parent years ago said that this house, this property was going to be left for the 3 children. Apparently along the way, a will was a will was drafted, and now that the parent passed away, the will was produced. What governs? Well, that verbal declaration that this property will remain in our family, probably heartfelt at the time, meaningful, maybe a little sentimental. It's not going to carry the day. The ownership of a property governed by the deed. You can't have a verbal contract concerning real property. It's not permissible. Besides, so if the deed just had this parent's name, maybe the 2 parents and then 1 parent, well, what will govern that piece of real property is the deed. Yes, the deed governs it, but what will control it upon the death of that person is the estate plan. So if that's a last will and testament, that governs. If it's a trust, if the property had been placed in a trust, then the trust governs. So it doesn't matter what people say. You need it in writing. You need it in writing, and you need it in writing for your benefit. So the thing is, that parent may have wanted to give the property to the second spouse. Together more than 30 years. At the very least, probably wanted that person to be able to live there the remainder of their days. But perhaps that parent also wanted to protect the children from the first marriage. You can't tell what is in the mind of a person. What did they say 20 years ago? What did they say 11 years ago? What happened last year? I never thought it would be me. I never thought this would happen to me. I heard that specifically yesterday, and I hear it quite frequently because family members think that they can rely on the goodwill of other family members. It's not true. Sometimes you'll have a parent promise something to a child. I'm going to give you the house. I'm going to make sure that you can live here all of your life. I'm going to give you this ring. I'm going to give you this watch, right? Certain declarations, certain statements that are made. I will protect you. It could have been heartfelt at that moment. It could have been intentional. It could have been the thought, but without proper documentation, proper planning, proper forethought, all that goes by the wayside. So I had a couple of prospective client telephone calls yesterday, similar situation. So one was about property, parent died, a second spouse, and what had been intended for the family, whether or not intervening will change some statement or some thought or some proposed plan. And then I had a different client call where there were family members. Again, it involved the house. Houses are the biggest thing in a state. But this circumstance was an elderly person that has herself, her daughter, and son-in-law property. How do you make sure you have it joint? How do you make sure that that property goes to the 4 children, that you do this with proper documentation? Is it the use of a trust or a will? You have to let me know what you want and what you would like. So in that second example, the homeowner, elderly person that's thinking about a plan is 50% owner with a child, right? Daughter and son-in-law in this example. How do we protect their 50% interest while protecting the mother? We could do it. So it's not even protecting the mother. Certainly is about protection, but it's how does she preserve that legacy, that 50% for the remaining children? And if she predeceases the daughter, would the inheritance by the other children push the daughter out? Or how do you protect that? Do you cause the daughter to have to buy out the other children? Do you say they can own it, but the sister's allowed to stay there for her whole life? Well, forethought, with calm, deliberate pre-planning, we can do it. You tell me what you'd like. I'll go through some permutations with you. We'll have a full discussion, and then we put into place a plan that's right for your family, for what you want to. What does any litigant want? What does any lawyer want in a contested court matter? You want the opportunity to be heard. If I'm making an argument on behalf of my client, my advocacy is what I want the judge to listen to hear, to feel, to resonate with, to vibe with. I just want a shot. Allow me to make the argument. Let me advance the position of my client. But then let the other attorney make an argument. Let that person advance an argument, right? Perhaps what I'm discussing is sometimes a judge will step on your feet or silence or be abrupt or not listen. Please allow me to make the argument. Then give the other side an opportunity to make the argument. That's beneficial for me. I get to hear the argument, the position they advance, the articulation of the position of the person and the rationale behind it. Perhaps listening to that can assist me in settling the case. It can assist my own client in hearing the argument advance. They can see how persuasive it is. They can understand that the argument resonates with the judge, if the judge is swayed by that argument. So it makes sense. If there's emotion and and it calls for oral argument. Allow us to argue the case. It makes sense. I dislike when judges curt or short and doesn't want to hear the counsel. I've heard enough. Well, you should hear it. Allow me to say it. I'm not going to be rude or discourteous or infringe upon your time. I just want to advance the argument once. So if you want to talk through these issues, reach out, take a look at the website, frankbrunolaw.com.